lawyers have to abide by certain guidelines in their engagement with clients and everybody else. Today on Law Express, we take a look at the lawyer-client relationship within the context of the obligations owed to the client by the lawyer. Stay with us. We'll go for a quick commercial break. When we return, we'll get into the topic. This is Law Express, and my name is Noella Seidu.
Nathan Yane is a private legal practitioner with a sincere dedication to mentoring younger lawyers. He is deeply passionate about everything beautiful about Ghana. Victoria Bath, a private legal practitioner and adjunct lecturer at the Ghana School of Law, channels her passion into mentoring young lawyers. Alongside her legal pursuits, she finds joy in reading and spending time with her family. Noella Seidu. She's a private legal practitioner and a consistent member of our 3-lawyer panel on the show every week. She also doubles as the host of the show. She likes to play tennis and read.
When you talk about lawyer-client relations, you're looking at the role of the lawyer in several capacities in how they relate to and offer advice to a client. A lawyer acts as an advisor, as a negotiator, as an advocate, as an evaluator in several capacities. But one fundamental thing to establish right from the onset is that even in representing a client, as a lawyer, you are an officer of the legal system, and you have an obligation to assure that quality justice is delivered in rendering your obligations to your client. There's an interface. And so it is important right from the inception of the lawyer-client relations to let the client appreciate that much as you owe a duty of care and a duty of loyalty to the client, you cannot also, in discharging those duties, breach your obligations as an officer of the legal system.
Let's situate the conversation starting from when there's the initial interface between the lawyer and the client. I know we are not allowed within our space or sphere to advertise.
Yes.
So how would a client know where to find that lawyer, and when that first conversation or interaction occurs, how are lawyers supposed to carry the relationship from them?
So I suppose people are aware that lawyers are required to practice out of chambers. Even for those who are doing purely solicitor work, the departments within the organizations where they work must be recognized as chambers, and so they are registered to conduct that their work from there. So every lawyer is required to be a member of chambers or the pupil of a member of chambers. And through that process, how clients approach you is already structured. Because whether or not we advertise, we're allowed to have websites, we have presence in terms of our physical location and the reputation of the people that you work with or work under. And so clients are typically going to approach you either through word of mouth or recommendations, or as a result of your work that they have become familiar with, or simply because they wake up one day and they check the legal directory and they find that they like your name or what you are doing, and
or
they
perhaps they saw your law firm signage at a junction.
Yes, and they approach you. So there are various ways in which you may be contacted by a client, and then of course there are subtle ways in which the law permits you to announce your presence, where you publish articles and so forth on your website or on LinkedIn, etc. But you cannot deliberately target a prospective client with a view to making what we call a pecuniary gain for monetary purposes. You are not allowed to do that. There are some exceptions where maybe it is by virtue of your blood ties or relationship which would require you to approach a member of your family or a close associate to offer your legal advice voluntarily. But other than that, it has to be a structured system, as I have outlined. Now, when you do get the opportunity to engage with a client for the first time, it may be that there has been a prior conversation, maybe the person has come to book an appointment or they've sent an email inquiry. So you may have had prior opportunity to highlight a few things like, oh, there may be a charge when you come in for a consultation. Sometimes also they just happen to walk in. And they are fortunate to have an appointment with you. Now, that's the initial engagement or interview. Now, in that interview, it is important for you to begin by outlining a few things, even before you start taking information from the client, which may be information that will be confidential or will put you in a position to act to the detriment of the client should you not end up acting for them.
Yeah.
So it's important to let the client know, first of all, that this is not a free consultation. These are the likely charges because of who you are meeting, because, you know, lawyers and as hierarchy, we are very particular about that. And we have a scale of fees that prescribes what you may or can charge depending on your level of seniority. So the charges you get out of the way. Then you also want to touch on conflict. It's important for you to let the client understand that in the event that what they require you to do, you have a conflict, that would mean that you would not be putting their interest first or pursuing their best interest because there's another interest that conflicts with what they want you to do. You will not be able to take on the instruction. So you don't start hearing the whole story before you say, oh, but. So if the person has come to you, for instance, is a wrongful termination matter, who do you work for, or who is it that you're seeking advice in connection with? Maybe your firm happens to work for that company. Yeah. So as I said, that some people may book an appointment, they may send you a prior inquiry. In that instance, you run what we call a conflict check to make sure that you are not conflicted regarding this client that is walking through your doors. You cover that. Another thing you want to touch on is confidentiality. And that's important because, you know, the whole idea of what lawyers do is that we are placed in a privileged position where people place trust and confidence in us. They divulge information that they would otherwise not disclose to the third party that they meet in an office or on the streets for the first time. So it's important to engender some trust and confidence by letting the client understand that everything that we discuss here, you know, I am bound by a code of ethics as a lawyer to keep in confidence that which you disclose to me, and I cannot subsequently even use it against you. Then you want to let the client know about client autonomy. Client autonomy means that you as the lawyer, you are going to explain their legal rights and obligations in connection with the subject matter they've come to consult you. And once you have done that, they are the ones who decide on the options that they have on the resolution of that matter. So you don't choose for them, but you empower them to make a choice. And then you also explain that once you have made your choice, you trust me to apply my legal knowledge and expertise, in quotes, to undertake the representation.
So what you're explaining is that the client ought to know what the options are. Yeah, so it could be a part through litigation, it could be a part through mediation, arbitration, or even by correspondence, where you write letters demanding, and then it resolves it. Once you let the client know all these options, then they decide, I want to be on this path, and you show them the consequence of that path. If it's litigation, you have a 50-50 chance of success. It might take longer, so you explain all, and then the client now instructs you, the lawyer, to pick which of the options they're comfortable with.
Yes.
So you can see from the first meeting with the client, there's a lot expected of the lawyer and a lot expected of the client as well. The lawyer is wearing different hats. At the same time, he's listening. At the same time, she's advising. At the same time, she's evaluating. Same time, analyzing. So the lawyer is wearing so many hats. But these are all intangibles the lawyer is doing. Sometimes the problem with the client is that the client doesn't see the importance of these things, you know, because every lawyer sells three things: your time, your integrity, and your intellect. These are the things that are packaged as a service to the client. So it's necessary for the client to appreciate these things, and these things are not free. You see, you have a problem where sometimes people would get your phone number from somewhere, just call you and immediately start, I have this issue and I want to talk about it and stuff like that. Sometimes when you even tell them that, well, you have to book an appointment so that you can come see me about it, some people get offended by it. Because the assumption, I don't know, people think that lawyers are just happy to pick up other people's problems and then, you know, start running with them. But no, the lawyer is a business person. The lawyer is selling a service.
Yes.
Yeah.
So you have to find the time, go and meet with a lawyer, and then go through the exercise of explaining to the client, the lawyer doing the evaluation, the analyzing of the problem, and then advising on the approach, the best approach to deal with the issue. Now, as my colleague said, client is autonomous. You have to take that final decision that this is how I want it done.
Because it's your case.
Because it's your case. But then the lawyer's responsibility is to advise you on the options. So when you know the options and you have decided on which of the options you are going to use, then you give the instruction, let's roll with this. Then you start working.
I remember my managing partner, Mr. Sori, always says that we are just soldiers waiting to be instructed.
Exactly.
So you don't take the decisions for the
Exactly.
clients. And it's important that we keep stressing that from the moment you walk into a lawyer's office, the clock starts ticking because it's work.
It's work.
At that point, the obligations owed to you. Of course, it might be limited where you don't touch on everything. But even the initial comments about who you're trying to sue or who is suing you has to be kept, you know, as, you know, confidential. So it's not a free service. You need to appreciate the fact that if the lawyer decides that you can consult for free, it doesn't mean that that is the norm.
Yeah.
It's just probably an exception based on whatever reasons. Talking about legal fees, I know Mrs. Batt already touched on that as one of the things that have to be disclosed at the very first meeting, so you know how much you're paying, you can negotiate it and all of that. Can we talk about the fact that lawyers don't just conjure numbers? We are bound by some regulations as to how we can even charge legal fees for services. So there's a scale of fees which guides each kind of case based on how complex it is, novelty, the time that will be put into it, the number of years of the lawyer, the expertise, all of those things come into how much is charged at a time.
Well, it starts actually with the Legal Profession Act, which regulates how lawyers conduct or render their services. And in that act, there are provisions on how lawyers can charge. And that's the first place that reference is made to the scale of fees that you referred to. And so, in as much as when a client engages a lawyer, there's room for negotiation. The lawyer negotiates within a certain framework. People may have encountered lawyers who quote their own fees without reference to the scale. Well, 99 days for Tiefman, 1 day for...
Well, it might be good for as long as you're going way under the scale of fees.
Yes. You may have a discretion to charge a very moderate or nominal fee. It may be because the client you are dealing with does not have the wherewithal to pay what the scale allows you to charge. That's allowed. I mean, part of what we do as lawyers is to ensure that justice is served in whatever capacity a client approaches
To
us.
everybody.
But then what you are not supposed to do is to undervalue the service where the client has the capacity to pay, and you are doing that either to undercut your competitors, you know, because at the end of the day, you don't just sell yourself short when you don't charge the right amount.
Profession.
Exactly. So it is important that you adhere to the guidelines prescribed by the scale of fees, which, as I said, provision is made for in the Legal Profession Act, and then it is done by the Ghana Bar Association Scale of Fees Committee. So there's one from 2022, which is the prevailing one. And then we also have the legal professional conduct and etiquette rules, which has a specific provision on fees, and it also makes reference to the skill and all those things that you mentioned. You take into consideration. You even have to look at the fact that taking on a particular case will preclude you from taking on other cases for a certain duration. You have to look at reputational risk. There are some soft things that factor into how much you may charge. So you may come to me to help you recover land that somebody has trespassed on, maybe in this vicinity. Another person will come to me with the same case, same size of land, but the nature of the complexities involved in the two cases will be different.
Even the parties.
And so, for instance, the scale may provide a minimum charge of 10% of the value of your land up to a maximum of 20. But whether I charge you 20% and 10% for the other person is dependent on the peculiar facts of everyone's case. And it is important that as a client you ask the right questions, and the lawyer also makes full disclosure. And that's why there's a minimum and a maximum end of the prescribed fees. And you must know that you are entitled to negotiate. And if you can't afford it, by all means, move on to the next lawyer. In the same vein, if I also feel that I'm not getting value for my service, I'm not bound to undervalue my service, because the two of us may understand the law, but how we apply, how we execute will not be the same. So when you know the value of your service, you price right, and clients have to appreciate that. And it's important that clients understand that there are two components when it comes to charges. There's the lawyer's fees, which, as he said, we charge you for our time, our integrity, and our intellect. Then there's the expenses, which is what you pay for administrative costs that we incur. If we use paper to print letters for you, that cannot come out of our fees. If we have to get from the office to the court to conduct your case, that cannot form part of our fees.
The filings in
court fees and all those. Those are expenses that you must pay for. And so typically you'll be required to pay a deposit on account, which the lawyer will be taking from, because I can't be calling you every day, oh, the letter is ready, bring 100 cedis for transport. It's not practical. So you pay a deposit, but under the scale, those monies that are deposited for purposes of expenses, you cannot hold on to it if, for instance, you finish the case and there's an excess. You must account for it. You must refund unless there's an agreement to offset it against fees that are outstanding. And the expenses must also be charged at cost. It's not supposed to become an avenue for you to make extra fees, such that when your cost of printing is 1 CD per page, then you now say 5 CDs. You can't put a premium on it, you know. And it's leading me into another area, which I'm sure you will continue on.
But before then, regardless of the nature of your charges or how you agree to take your fees and other expenses, the funds for other expenses, it's important that it should be drafted, signed, so that both parties have a clear path as to how the funding and finances will be distributed. We'll go for a quick commercial break. Stick with us. We'll be right back.
It is quite important when it comes to money for the lawyer to be able to separate accounts to ensure that there is no mixing of monies that come into the practice. Of course, nothing received from a client should be put in a lawyer's personal account until such time that the money has actually been earned. In the same way, if money is received on behalf of a client, the lawyer should make sure that that money is kept separate. So lawyers usually will keep several accounts with a bank, each with a particular purpose. It is very important, because if you are not careful and you receive money on behalf of a client and then you mix it up with your own personal funds, I mean, you're human. Things can happen. Money gets missing. You might apply it to something that may not necessarily be in favor of the client. The client needs the money and then there's a problem. You can't trace the money.
Yeah.
These are things that result in a lot of people ending up before the disciplinary committee. So it's very necessary for lawyers to ensure that they have separate accounts at every point in time, so as not to mix clients' money with their personal funds. And especially with monies received for admin fees.
Yeah.
It is very necessary that you also make sure that you hold this account separately and be able to account for it, so that if at the end of the case, as my sister said, if there is something left, it is for the client, except where the client has given an indicator that when that happens, it can be offset against fees. So these things are things that are supposed to be put in writing. That is why it is best practice for a lawyer to ensure that at the time a decision is taken to take a client's case, there should be an engagement letter or a fee agreement, so that these things are spelled out and nothing would be, nobody would be taken by surprise.
Well, it's for clarity first, but then it protects both parties.
Exactly.
There have been instances where clients don't want to pay or think that maybe they didn't negotiate properly and want to now renege on the whole contract because it's a contract for a service. So having it documented helps. I mean, paper or book no lie. So when it matters most, you pull it out, especially where the client probably after the whole case decides that I'll be greedy, I don't want to pay.
Yes.
And this normally arises with a contingent arrangement. I mean, for the period that the client needs your help, they are okay. They will listen, they would play along with you. But once they now see the money, there's a judgment, probably they didn't anticipate it to be that much, and then they start spending the money before they get it and start diminishing your service to them and the value of your time.
Or for instance, when they lose the case and you've still done your work, but as far as they are concerned, they are not getting any value because they've lost. But you see, that is something that you would have explained in the first meeting when you talk about what their rights are, what their expectations should be, what their options are, and what the likely outcomes may be. So either you're going to win or lose. I remember you said 50. So, I mean, in recent times, the Supreme Court has ruled against a lawyer who didn't have an express or clearly written out agreement. It was like an ad hoc thing going. And at the end of the day, the lawyer wanted to charge a certain amount. The client refused. And the Supreme Court ruled in favor of the client that once you failed to ensure that this agreement was reduced into writing, even if not at the inception, a reasonable time thereafter, you cannot now insist on a figure that there's no evidence was agreed on between the two parties.
Because there's no proof that you both were in agreement in figures. And perhaps you're just taking advantage of the situation because you now know the full details of how much he's going to make or she's going to make. What about, once we're still on money, let's talk about borrowing from clients.
That's prohibited. You know, I made a reference to conflict of interest. I think there are a few things there to highlight. For instance, you can't borrow from somebody who's your client. That would lead to a conflict situation because it compromises your ability to exercise independent professional judgment. And that's something that as a lawyer you must jealously guard when you are representing a client. But if you are beholden to the person because you've taken money or some favor from them, you know, when you get to a point where you must stand your ground and say, this is not in your interest, I'm not going to do it, you are already in a position where you have, yes. And one of the duties we have is not to put ourselves in a subordinate position, you know, when it comes to instructing on the law. So it's a no-no. It's actually spelled out in...
I want to poke the bear a bit more. What if the client is a banking institution?
There's an exception there, because their usual course of business is to give loans to everybody, not you alone, and you are not going on any preferential terms. So that's an exception. Another thing is not to have an amorous relationship with your client. Nobody is forbidding you to fall in love. But the moment that crops up, you have to withdraw your representation. And it's not just you, it affects other lawyers in the firm.
At what point do you come to the place where you realize you fall in love with your client and for which reason you need to withdraw? How do you measure this?
Because I think if it's infatuation, then the other party doesn't know. But if you've gotten to the point where the two of you are expressing feelings for each other and it will have a direct, well, whether or not it's going to have a direct impact, it's one way or the other is going to affect your judgment. Imagine having an argument with your girlfriend and turning around to try and advise her on an issue. So once that crops up, and you have to be aware that it's not just you. Every lawyer who works in that firm, once you develop that relationship, you are potentially also disqualifying them from having something to do with the case. So you have to be very careful.
So what about husbands representing wives as clients?
Not ideal.
Yes.
It's not ideal, but it's not banned. It's not something that cannot be done.
But it is, I mean, because the emotive aspects of the relationship can cloud your judgment.
Yes.
And that can actually lead to problems because the emotive factors may be a reason why you may not take a certain approach which may bring a quicker resolution
This
or
is
a
like
more
doctors
practical.
as well, right?
Exactly.
Yes. But I still hold the view that if it's a marriage and you think that perhaps there will be no compromise in terms of your professional conduct, it's not totally out of place because sometimes you might know more to make the case work out better.
Yes, but it's still better to get somebody else with an independent.
Yes. You just like that
with-
arm's length approach. we sampled people's opinion on this
Yes.
topic,
Okay.
and we would take a listen and react, and then continue our conversation.
Responsibility or obligation that a lawyer owes his or her client is the obligation of confidentiality. It is just lawful for a lawyer to be confidential enough about the kind of information that he or she is trusted with by a client. And this is to say that as a lawyer, you are not supposed to share or tell people what your client has told you. You're not supposed to share that kind of information with people. Like, you're supposed to treat away all the confidentiality that is needed.
One of the obligations between a lawyer and a client is communication. The lawyer is supposed to tell the client the status of his case so that the client will know what to say at the court or how his or her case is going.
I think a lawyer's obligation to his or her client is to defend him or her at all costs. Because regardless, I'm the one paying you, supposing I'm the client. And then he has to be fair and honest with me to know how my case is going and all that. Yeah, so
it's the duty of a lawyer to represent his or her client in court or any legal forum. This is to ensure that the lawyer is able to protect the rights and interests of his clients.
Wow, it's refreshing to see that most people get it. They know what to insist on. The standout for me is the lady who says lawyers must defend their clients at all costs. I mean, we should be ready to die at this point for clients then.
As we have already said, the lawyer is a counselor. He evaluates, he analyzes, and advises you on the options available. Every matter would have several options, in terms of trying to resolve it. It is not always the case. Sometimes people see lawyers as ready to pick up, their swords to go fighting on every issue. But sometimes it may not need, a battle in court. That is why the lawyer is first a problem solver before being a gladiator. The lawyer will try to find a way to solve the problem. If it means talking with the other side.
Yeah.
It's part of the lawyer's work. If it's a matter of engaging in written letters, it is part of the lawyer's work. If everything fails and the lawyer is supposed to then issue a writ of summons or something like that, then of course the lawyer is equipped to do so. So when you say that the lawyer must represent you at all costs, if your case is a bad case, if it's so hopelessly bad that even the process of litigation is going to go against you because you'll be spending too much money, which you're not going to get back, at the end of the day, shouldn't the lawyer be honest enough to be able to tell you that you do not have a chance?
Yeah.
So it's necessary that prospective clients have that understanding that the reason why the lawyer is called counsel is because of that element of the lawyer being required to advise. And it is the advice that tells you whether you have a claim that is necessary to pursue at all or something that you should not pursue.
Let's bring in some practical aspect to this conversation. I noticed that there are clients who come in, especially with defamation suits, and they feel offended. It's become an ego thing. So you explain to the person that yes, the person might have uttered these words, but they are not defamatory in a sense that will make you succeed in court. But they will insist that issue a writ, and where you back off from such, then the client goes away really, really upset. And especially with defamation, even where the client has a case, you realize that it takes years sometimes to come to judgment. And over time, the tempers calm down. People might have forgotten what even happened. And you're still saddled with this case, which travels for years, to a point that you realize the client at some point has even lost interest in the outcome because Ghanaians have moved on. They no longer remember what even transpired. But there are these clients who always want to go straight to court. Even when you give them the option of correspondence, the option of other alternative dispute resolution mechanisms, they still just want to go to court. And they want to see you screaming, showing, displaying. And on top of that, they don't even want you to be nice to counsel on the other side anymore, forgetting that
Don't talk to your own colleagues.
forgetting that you have relationships. These are people that are your colleagues, and way after that case, you would continue to deal with them on the daily.
Let me just rewind a bit. I'll come to such clients. But defending at all costs, when people say that, makes you wonder. And that's why in the beginning I said that clients need to be made aware that in as much as you owe them a duty to act in their best interest, you owe a higher duty to the judicial system to be candid to a court if you happen to be involved in litigation, to ensure that you do not breach any of your duties as a lawyer who is to keep their ethical obligations to another party or another lawyer, because our rules require us, even when we are aware of an authority that is contrary to our client's interest, to disclose it to a court. So a person may think, oh, like she said, I'm paying you, defend me at all costs, but you will have to let the client understand that no matter how much money you are paying me, a time will come where I may have to withdraw from representing you, or I may have to make certain disclosures that will not be in your interest, or this is how far I can go because I will be exceeding what the rules of the adversarial system allow or permit me to do legally. So they must be aware of that. Then, as he mentioned, legitimate compromise. We as lawyers are actually duty bound to encourage settlement where a matter will admit of fair settlement. If we fail to let the client become aware that there's that option, they can take us on later before our disciplinary body. So you have to let a client appreciate all those things. But when you come to the person who still insists that regardless of the merits, proceed, there's a fine line. So one, I will ask, will proceeding be unethical? Because then it's a no-no for me. If it's not ethical, I'm giving you a written opinion with a full disclaimer that I've told you that this is not your best option. And you insist that regardless of the cost implications, the time that it will take, and the fact that you are highly unlikely to succeed, I should proceed. Once we have that down, I'll go and file the claim. And then you will be expected to pay for the time committed to it. And when we finish and we are unsuccessful, there's that reminder for you. But I mean, 99% of the time, I will not go ahead with such a matter. There must first of all be what we call a cause of action. If there's nothing really to go before the court for, I will not do it.
Because that will be an abuse of the court
Exactly,
process.
and there are sanctions in the Legal Profession Act against that. Pushing a case out of malice or where you know there's no probable cause. So you need to let the client understand. And clients come to respect you because they know that if my lawyer will not even do this for me, then this lawyer is not likely to be compromised against representing my best interest. Yes, I have a duty to zealously assert my client's position, but within the confines of what the law permits.
You mentioned defamation cases, for instance. Within the common law jurisdiction, that is taking all the countries that had some relation with the British, colonially and now, defamation cases only about, I would say, only about 95%, about, let's say 5% end up in court.
Yes.
95% of them are settled. You see, because sometimes it's even a risk to go the full haul in a defamation case.
Because then you open the can of worms for more info.
Because you put a value on your reputation. What if the court says that
you don't have, we are not up to
so
that
you
value.
may even win, but
you lose in the long run.
Yes.
Yeah.
So sometimes that is why it's necessary for the lawyer to be full and complete in the advice he gives to a client before the decision is taken to proceed with a course like that.
So we'll go for another commercial break. When we come back, we'll try to answer questions that came by way of social media.
Okay.
Don't go away. This is still Law Express.
Hi Noella, I'm from Pram Pram. I had gone to the court with my lawyer when he had an emergency, and I ended up lending him some money to solve the problem. He promised to pay me back in 3 days. However, it has been almost a month now, and he still hasn't returned the money. When I asked him about it, he told me to wait until we finished the court case. But that was not the agreement we had when I lent him the money. So how can I get the money I lent him back?
I think earlier we mentioned that one of the things you cannot do as a lawyer is to borrow from the client. In fact, you can't also lend to the client unless it's a contingency arrangement like we've discussed. And it is all because it compromises your independence and your ability to exercise independent professional judgment. This is a unique situation because there was some emergency, whether it was orchestrated or not, one can't tell. But you see, it's a different thing if somebody owes you legal fees. You cannot borrow money under, as it were, an emergency situation and then say, but you haven't paid my fees. But he's saying, let's finish. So my understanding would even be that the fees have not accrued yet.
Yeah.
So this lawyer has no business withholding that money. The client has every reason to send him a nice demand note, may even be via WhatsApp or by text, that if you don't give me back my money, I am going to take you where I will get my money, because you can be reported. But you see what this is doing is that it has now undermined the respect and the confidence that the client would otherwise have had in this lawyer. If you can treat me this way, you are supposed to be upholding my rights and fighting for me, whatever the subject matter. But now you take money from me and you want to hold on to it until you have discharged your obligations under a contract or an agreement which specifies when I'm supposed to pay you. That's not right.
Integrity. Very, very, very important. Because if this client goes out there and starts talking about this, people who hear this, the question is, would they say positive things about you? Would you become a choice for them should they encounter any problems and need legal services? Would they talk to other people about you? It will simply go around.
And come back.
And you tarnish your own image, and you tarnish the image of the profession.
And you risk losing your license
as well.
If you are reported.
Thank you, Noella and your team, for this educative program. My question is, I had to go to court recently because of some trouble I got into. I thought my lawyer had everything under control, but things didn't go well in court. I'd like to know if my lawyer is good at their job. How can I tell if they're doing a good job or not? And if they're not, how can I find a better lawyer?
A lawyer is as good as his brief. You know, so a client is supposed to help. You know, the lawyer cannot work magic. So if you have an issue, you've gone to a lawyer, make sure that you are giving the lawyer as much information as possible, the complete story,
and
to
the
allow the
supporting
lawyer,
evidence.
exactly, so that the lawyer will be able to advise you as to whether you have a case or you don't have one.
Yeah, this does not diminish the requirement of competence in our practice as lawyers. There are ways you can also check to see. I mean, if, but it's just hard because nobody can sit in judgment of another professional.
Exactly.
Yes, you expect some standards. You should be able to read. You picked your lawyer. So if you are not comfortable and you've come to the point where you're asking this question, it means you do not believe that this lawyer has the capacity and the expertise to handle your specific problem.
Yeah.
I would suggest probably move on.
No,
If that's
he or
what
she
it
is
takes.
asking how they find it.
Because
I think there's not even enough information to
Yes.
judge on what was the expectation set, what was the basis for the expectation set. For instance, if it was bail that this lawyer was going to secure for you, did they assure you that it was 100% guaranteed?
yeah.
And are you saying that maybe in the ruling that came, the judge made certain comments that is the basis for doubting the competence of the lawyer? For us as lawyers, whatever matter we take on, we represent that we have the competence to execute. In fact,
Yeah.
if you don't, you're not supposed to.
Yeah.
But the information is scanty, and so unless there's some independent means by which he or she has come to the conclusion that it is the lawyer's fault, then there's no guarantee that when you move on to the next one, like he said, it's going to change the facts. If the facts are palpably bad against you, sometimes you can only mitigate.
Doesn't matter who's your lawyer.
But if it's good and you've also done your research from your layman's perspective and you realize that, there are things that should have been done that was not done for me, by all means, seek advice from people you know who've used lawyers before. Check your capacity to afford those other lawyers and engage them.
So I live in the bustling town of Kumasi, and recently I found myself in need of legal assistance. I got caught up in a land dispute with my neighbor. In order to sort things out, I enlisted the help of a lawyer. Now, during the case, I provided funds to her to cover various expenses. But now I'm left wondering, should she be providing an account for every CD I've given her? I want to make sure everything is above board and my interests are being properly represented.
I mean, lawyers must first of all give receipts for every payment that they receive from the client. So this should not even be a question. You give receipts for the money, the receipt must describe what the payment is for. And then, as we said, you must render account, especially when the client is giving you money for expenses on their matter. And you must show them exactly what you have used the money for. And if there's any balance that this is it, it is their right to demand that. So for this client to be wondering, they should just walk up to this lawyer and say, so far, and it also suggests to me that there isn't a clear engagement letter or terms of engagement between them, because typically you would set out what the scope of your representation is and what the fees are and when and how they are to be paid. So that a client is not wondering what you are using a particular amount for and what it is being expended on. But she's entitled to receipts, she's entitled to be given an account. And where you are charged VAT and all these other levies, make sure that you are getting a VAT invoice, because it shouldn't be passed off so you pay and then it doesn't end up in the government coffers.
We're getting to the tail end of the conversation, and we've only just scratched the surface of it. We will require a second part of this discussion, because we will not do our audience any justice if we end it here. But I wanted to talk about, the requirement of for proper and effective communication between lawyer and counsel. But you find that some clients think that once they have given you a few CDs, They own you in totality. So they think it's okay to call you at any hour of the day, even at times that they should expect you to be in court. They keep calling. They think they can pop into your office chambers at any time and demand your undivided attention. And this is something that we have to put out there, that just as your case is that important to you, there are other clients with equally important matters.
Yes.
Sometimes even more.
Yes.
That border on their personal freedoms and all of that. Your matter might be a civil matter, which can always be managed. But somebody has a criminal matter before your lawyer.
Yeah.
So your time is secured and guaranteed. But allow your lawyer to work.
It is necessary for the lawyer to keep educating a client. Yes, there are clients like that because you've taken up a case, they think that they virtually own you. But as I have said, and I have always insisted, I am selling my time and my intellect. So you are paying for what I have set out or devoted to the work I'm doing for you, but you've not bought the whole practice. So we need to always educate our clients as we proceed. In some jurisdictions, as soon as you enter the lawyer's office, he presses a timer.
Yeah.
So when you hear the ding dong, you know that it's money.
You've clocked
running.
1 hour.
So in such situations, you wouldn't have people just pop into your office unannounced, etc. In Ghana, we tend not to go that way. And that is one of the reasons why sometimes people think that they can just walk in to your office. Sometimes social calls and stuff like that.
Especially because many people waive the charges for the first consultation.
Exactly.
Many lawyers let that one go,
Yes.
and then they take it from when they actually agree that they've taken up your case.
Exactly.
So when you spoil the client like that, then they think
True.
that any time of day, I was just in the neighborhood, and then they think you should leave everything else you're doing to chat. And there's also this category of clients that want to hang on to you even after the case is done. So because your case traveled for a long time with them, yes, you have built some relationship, but then they begin to think they are now a part of your life. So they demand to be at your personal events and insist you attend their events,
Exactly.
forgetting that you still have to work,
Exactly.
for hundreds of other people. How would you function if you carry it beyond that? Clients have to understand that when the brief is over, it is the lawyer's decision whether you're still friends or
Exactly.
not, because it was a business and contractual relationship, and you've not now been adopted as part of their household.
I think
That is true.
setting boundaries is very key. You have to set boundaries right from day one. And sometimes it's what you allow that becomes the norm. So it's important for a client to understand that, yes, you are paying for my time, but these are the hours that you can reach me. So typically for those of us who are litigators, you don't call us in the mornings. We are getting ready to go to court. You will not get our full attention. So you know that between this hour and that hour. And another way you set boundaries is not to pick your phone when they call you outside those hours.
I think this is a great point to stop this conversation today. We would continue again next week. So same panel, same time. We need to exhaust this. Even if it takes 3 episodes to do that, we're going to show up till we get people to understand our perspective. Yes, we're giving you our time, we're giving you our credibility, we're giving you our expertise. But then we also have lives. We are human, and you can own us. This has been our show. Thank you, Mrs. Victoria Bath and Mr. Nathan Yani, for honoring our invitation to be on the panel today to discuss the topic, the lawyer-client relationship within the context of obligations owed by the lawyer to the client. My name is Noella Seidu. Same time next week, join us again for a second episode on this same topic.